Welcome back, ladies and gentlemen, to a brand new legal breaking analysis video. Today we have a legal breaking analysis video reporting from Politico on what judges can do if, in fact, Donald Trump, which that seems to be unfortunately, illegally, unconstitutionally, unlawfully, and wrongfully what he's doing. On what they can do if he, in fact, defies court orders of theirs. What all does the reporting from Politico detail? Well, let's just take a look at it and break the analysis details down today. This article is titled, If Trump defies the courts, here's what a judge can do. A former federal judge weighs in on the escalating tension between the White House and the Judiciary. By Yankesh Cardori. Yankesh Cardori is a senior writer for Politico magazine and a former federal prosecutor at the Department of Justice, where he specialized in financial fraud and white-collar crime. He also has also worked in the private sector on complex commercial litigation and white-collar corporate defense, and the political dimension of the law at a moment when the two are inextricably linked. And the article reads, amid the growing battle between President Donald Trump and the courts, a once unthinkable question is harder to shrug off. Will the Trump administration deliberately defy federal judges if it doesn't get what it wants? The issue has come into sharp relief in the challenge to the administration's deportation of Venezuelan nationals under the purported authority of the Alien Enemies Act. The presiding judge, James Boasberg, chief judge of the federal district court in Washington, D.C., directed the government from the bench to turn the planes around carrying the deportees. That did not happen, though the administration claims it did not deliberately defy the judge. Boasberg has since pressed the government for more information, and on Friday he will hold a hearing to consider the matter further. Ladies and gentlemen, let's be clear. This hearing already happened. And Judge Boasberg, BOSBERG, said he determines to get to the bottom of this, which, by God, I hope that he rightfully, legally, constitutionally, and lawfully does, per his oath of office. Continuing with the article. To consider Boasberg's opinions and the implications, I spoke with Shara Scheindlin, who's a former federal judge in Manhattan who served on the bench for 22 years. She is no stranger, to complex, high-profile disputes involving the government, and as I attest from brief personal experience, I once litigated before Judge Scheindlin. While I worked in the private sector, she had a well-earned reputation for exercising firm control over her courtroom and the lawyers who appeared before her. Scheindlin said that in the debate over whether the United States is already in a constitutional crisis, the real red line is if the executive branch defies the judiciary, a move that Trump says he wouldn't take. Clearly, ladies and gentlemen, Trump lied. This is a move that he is taking unlawfully and illegally.
I don't know what you're doing. I don't need to leave you alone.
That's when authoritarians become dictators and really tear down the temple by just ignoring the Constitution and ignoring the judiciary. She said. She added, quote, "That would be the shocking end to our 250-year experiment," end quote. This interview has been edited for length and clarity. Did you ever confront a situation where there was a credible suggestion that the government had deliberately violated one of your orders? No, I don't remember such event happening. In the case over deportations under the Alien Enemies Act, the government has argued that there is a difference between an oral order and a written order from a judge, that oral orders are somehow meaningless if they aren't immediately embodied in a written order. What do you make of that argument? That it's creative, that's all I can make of it because I've never heard of it before. When a judge makes an order from the bench, they sometimes say at the end that, that's my order, or so ordered. It's tough to appeal an oral order unless that's a certified transcript, given that this is a high-profile case. I bet he had a court reporter in the courtroom. I bet there is a transcript, and I bet they could have appealed it based on the transcript. I have had that happen where it was so urgent that a litigant took the transcript, got up to the second court, and said, she's wrong. Judge Boasberg has scheduled a hearing for Friday to determine next steps. The government has been making submissions in response to his orders, but they've been somewhat tentative, somehow defiant. If you were Judge Boasberg, how would you approach this hearing? I think he's posed very specific questions to the government as to when certain flights took off. When did certain flights land? Who gave the order? Who was in touch with the administration after he issued his oral order? I'm sure he has a lot of questions that he thinks the government has to answer, and I think the government so far has been evasive in answering such simple questions. It is not hard to answer the questions I just gave as examples. What was the flight? Name and number. What airport did it leave? What time did it land? Who did you speak to after I gave my oral order? What time? He knows that the time of his order, that's probably on the transcript. Those are kinds of questions I think I would be asking on Friday. Assuming that Judge Boasberg, assuming that the Judge Boasberg, or any other judge for that matter, eventually concludes that the government deliberately violated a court order, what are the judge's options? I can tell you that even every former judge I know has been asked this question by somebody in the media, including me. I think the only real option is civil contempt. The reason why it cannot be criminal contempt is generally that would be referred to the Justice Department to prosecute. So you might have a lawyer, a witness that you direct to answer a question, they refuse and or they lie. If you want to charge them with criminal contempt, you have to get the U.S. Attorney's Office or Maine Justice to prosecute. And clearly the Trump Justice Department or the Bondi Justice Department is not going to prosecute. Then you get that question, which was raised in the Eric Adams case. Could you appoint a special prosecutor? That's tricky because of separation of powers. I think criminal contempt is off the table. I think Civil contempt, however, is something that could be done if the facts are fairly straightforward. The remedy in civil contempt, believe it or not, can include incarceration. Usually it's fines. If it was a lawyer, you might file a grievance against the lawyer. That could be done if these lawyers either lie to the court or personally violate the order. When you want to bring a grievance before the grievance committee of the local bar where they're admitted, something like that. Ladies and gentlemen, note that these corrupt, ambiguous, illegal lawyers of Donald Trump are currently violating and lying to judges consistently because they do not know what the hell they are doing. They are uneducated, incomplete numbskulls. Continuing with the article. So it could be fines, could be a grievance, but in theory, it could also be jailing somebody. I did that only once in my time on the bench. In a civil contempt case, I actually put somebody in jail because he was so defiant and then he did what he was told to do. You could also sanction the person, and that's always interesting because you could have fines that double every day, so it can get serious fast. I don't know how good at math you are, but a $1,000 fine doubling every day can quickly add up to real money, not for the United States government, but for an individual. If somebody was individually sanctioned, that adds up. How would incarceration work in civil contempt? Would you still need the involvement of the executive branch? Well, you need the person taken away by the U.S. Marshal. That's the problem, right? When I held somebody in contempt, or civil contempt, I had to say, Marshal, take this person across the street to the jail. That is part of the executive branch, just the U.S. Marshal escorting the person over to the federal facility. So it still has that problem, but you don't need a prosecutor. There have been reasons to doubt the veracity of the DOJ's arguments in court since the start of the Trump administration. To take a couple examples, the arguments about why the prosecution against Eric Adams is being dismissed, and the arguments about why some civil servants have been fired. How do you approach a situation where you might not fully trust the reputations that the government is making in court? That's a very good question. You have to try to develop evidence extrinsically to prove that falsehood. We talked about being evasive, in other words, just refusing to answer or ducking the question, that actually making a false statement to the court. You would have to have extrinsic evidence that it's false. If opposing counsel was able to find out what flight, what plane, where it left, when it landed, and it turns out that the government lied and said, well, the plane took off before your order. Let's say it turned, excuse me, that's bad. That's a grievance to be filed against the individual attorney who is an officer of the court, but you'd have to develop extrinsic evidence. I can't just say, I don't trust you. I don't think that would work. You could say, I'm very doubtful that you have been candid with the court. I'm concerned about the veracity of what you've told me, but I'm not going to take action without facts to prove that you have been dishonest with the court. Judges do have a sixth sense for that. They've been around. Judge Boasberg also has been around a long time. He's very experienced. I think you kind of know when you see it. Know it when you see it. The lawyer has an ethical obligation to be candid to the tribunal. Are you worried that we'll see a situation where the government explicitly and outright defies a court order? I am concerned about that. We've been talking, we being civil society, everybody, about whether we're in a constitutional crisis. Everybody keeps writing an opt saying, not yet, but almost. The constitutional crisis will occur when the executive branch says to the judicial branch, too bad, I don't have to listen to you. That's a constitutional crisis. And we haven't quite gotten there. It seems to me that the executive branch is getting as close to that line as they possibly can without crossing it yet. But if they really just say, we don't have to listen to you, that's very bad. There have to be 3 co-equal branches of government, and each branch has to respect the other. What do you think happens in a situation like that, particularly if it's a Supreme Court ruling, in terms of the public's confidence in the judicial system and the effects on the American politics? American politics. If we really had the constitutional crisis that I just described, where the executive branch says to the judicial branch, I don't have to listen to you, that's a very, very, very serious threat to our democracy. We are built on the separation powers. We're built on 3 co-equal branches of government. That's the authoritarian dictator saying, I'm tearing down the whole wall. That's when authoritarians become dictators and really tear down the temple by just ignoring the Constitution, ignoring the judiciary,